Now back to the show. This is AM 650's The Law Show.
Welcome back. We're talking family law with our guests from Henderson Heinrichs here in Vancouver. The firm, by the way, is a family law firm, been around for a dozen years. The offices are on West Georgia, 1188 West Georgia, and a fledgling operation in downtown Toronto just opened as well. Soon to be on the North Shore, rumor has it. And they're online at hhlaw.ca. And on that website, you'll find our guests, Shalina Sayani and Sonia Kainth, who are both lawyers with Henderson Heinrichs, and both family lawyers. And we were just talking about the collaborative process before we took the break. I had asked you, Shalina, the differences, the definitions, if you will, please. We're talking collaborative law, but there's also now inclusion of mediation and arbitration. We know both of those terms, especially in British Columbia, the land of the strike. We know both of those terms from labor law.
That's right.
How would they apply in a family law context?
Okay, so family law mediation now is regulated again by the Law Society and the mediation roster of BC, and there is a certain level of training that now has to be obtained before somebody can be a family law mediator.
Okay.
Which really increased quite a lot in the last year.
Drastically.
As well. Yeah.
Drastically. So people that have been mediating unofficially without the certification for maybe 20 years didn't have the qualifications on paper that they needed to satisfy the Law Society.
Oh.
So
they
we
had
were
to go out
all
and
running around
retrain.
trying to get recertified, further training, new training, just to meet the requirements. And again, like collaborative mediation training is ongoing, because you have to keep your skills current.
So what would the difference be in a mediation? Because collaboration, you've got lawyers and possibly divorce coaches from both parties, and they're trying to resolve their issues amicably.
Right.
So how would that differ from a mediation process?
So mediation process is, again, an amicable setting, you hope.
Well, one always
as it
hopes.
can be,
Right,
as
right.
best as it can be with the family dynamics
Of
that
course.
are going on.
Sure.
So the parties generally select a mediator that they feel comfortable with. Again, there's lists of qualified family law mediators. And the mediator is a neutral. So the mediator is there to help the parties reach resolution together. They're there to reach it. There's no imposition of this is how it's going to be.
Okay.
So it's not like arbitration. Arbitration is like a private judge. So they will come to you. You will be selected as the family law arbitrator. And it's
Because again, going back to labor law, one hears of the term binding arbitration. So both sides present their stories.
Yep.
The arbitrator makes a decision, and it's binding on both parties, like it or not.
right.
And is that what you do in family law
That's
too?
what you do in family law.
So kind of like a judge with the same outcome as a judge, but minus all the trappings of court.
Absolutely. So you agree with, as if you're the arbitrator, what happens is you create the process with the parties. Now, parties can come to arbitration with or without lawyers, as they can to mediation. So some mediations are done just with the parties alone, and some are done with the assistance of counsel. And often it's a hybrid. Sometimes you'll just start off with the parties working with them at a mediation, and they hit, let's say, an issue about spousal support that neither of them can just work through.
Right.
And so you can say to them, look, you need to go and get independent legal advice on this issue, because as the mediator, you're not giving them law. You're helping them come up with a solution that's within the framework of the law, but you're not actually giving them legal advice. You can give them an educated guess of what might happen if they were to go to court, because if you're a family law mediator, you're often a lawyer as well.
Sure.
So your lawyer hat absolutely is doing this. The little voice at the back of your head is giving them that reality check. And often I'll say to people, if I'm the mediator, go and bring your lawyers and let's have this conversation with the lawyers, because you don't want it to break down because they're stuck. There's always another way to do it. So the lawyers can come, and you can have mediations with everybody in the same room, or two separate rooms, and the mediators going back and forth.
As is a typical labor scenario again, right? Sure.
You shuffle down the whole room.
Absolutely.
Well,
That's
okay,
right.
now
Right.
we're arguing about 2 hours as opposed to the weekend, or arguing about $2,000, or whatever the issue is. And hopefully with the assistance of the lawyers who are there to buy into the process of mediation, they will come up with a mediated outcome, which will be incorporated in a separation agreement, which forms the basis of their settlement.
Oh, okay.
But with the arbitration, they come with lawyers and they present their evidence. So both sides decide how this is going to be presented to you, whether it's going to be written format and submissions, or a combination of that. And then the arbitrator, as the family law arbitrator, gets to make that decision. And the training in it, again, you have to have at least 10 years experience to be a family law arbitrator. The training is really
Very intense.
Very intense.
So you would choose the arbitration route as a sort of inexpensive court? Is that how a lot of people treat it?
Yes. And also to give you more control over the process. Because if, let's say, you're looking for court time, you can be waiting for anywhere from a year to 18 months or more because you're just
Like for a full trial.
for a full trial.
Right.
Even if you book a one-day hearing, we didn't talk about this before, but the delays at court right now are such that you can sit and wait around for a half-day application. You can go to court 3 or 4 times, and you're paying the lawyers to wait.
Well, yeah. I have a friend who was involved in one of these issues who was in court to just petition for a certain change to one of the terms of the separation or whatever it may be, and sat all day in the courtroom. At the end of the day, the judge simply said, too many criminal matters. See you again some other time.
Yep.
And that was that. So the lawyer's day and all that fee and my friend who should have been on the job working that day,
Right.
all just money. You might as well just take it out in the parking lot and set it on fire.
Absolutely.
For all the good it did for that day.
Yeah.
So if you can avoid all of that through arbitration, which is similar,
Very similar.
but a lot less expensive.
And you schedule it around the lawyers and the client's time, and
Right.
you've got a set time that you're not going to get bounced. You know that the arbitrator is going to have read the materials ahead of
In
time
advance, yeah.
and is
Which
going
is
to
really
know what your
important.
case is about. Because often you'll have a court application, and you'll think you have an assigned judge, and last minute you'll get referred out to a judge that hasn't read your file.
Sure.
And we often tell people, listen, I'm sorry, skipping around here, and I apologize, but when people come into our offices for, the initial legal advice, we tell them, there's so many different ways to deal with your separation and divorce. And ultimately, sure, you can go into a courtroom and you can ask a judge to decide, but here's how we ask people to look at it. They know everything about their life. Absolutely everything.
Right.
The lawyers will probably know this much. The judge isn't even going to know a centimeter's worth of
A
their
complete
life.
stranger.
And that person is going to make a decision as
Right.
to the rest of their life.
Right.
And often neither one is going to be happy, so it's going to prolong the litigation. Whereas with mediation, they're buying into the process, they're customizing the solution, and because it's working for both of them or their whole family, there's going to be more compliance.
Right. Sonia, what happens when someone comes to your office, and these initial conversations are free,
Yes.
aren't they?
Yeah.
People come to Henderson Heinrichs, and they're just a mess in a lot of cases, just an emotional basket case, and I've got to talk to somebody. So they talk to you. But what happens when somebody comes to the office and they are seriously angry? I mean, really, really angry. Beyond, it's irrationally angry, to the point where all they want to do is go to court and seek revenge. They want to
Revenge.
they want this
Blood.
person punished.
Yeah.
It's not good enough that the whole world knows that they've been a jerk or whatever.
Right.
No. This has got to be in court on the public record, and I'm not going to settle for anything less.
Right.
How do you talk a person down off that high horse?
Well, it's really interesting. I actually had an initial consultation a couple weeks ago along the same lines. So basically, the client came in, and clearly they're upset when they're coming to you. Their relationship has just broken down and stuff. And so, what I typically like to do is I just kind of let them vent a little bit.
Yeah.
Because once they get that out of their system,
Yeah.
they can listen to what I have to say.
So eventually, they're going to have to pause
Yeah.
for breath, aren't they?
Yeah. So if they're really up here, it doesn't.
There's
make
no point
any
engaging
sense.
with them, right?
No, it doesn't make any sense for me to match them up here because
Sure.
they're not going to listen to anything that I have to say.
Right.
But if they are up there and they vent a little bit and they come down and they take a pause and then I'm able to jump in and they're just asking for ridiculous things like,
Right.
I want the kid 100% of the time and, there's been no parenting issues before, but, she can't parent or whatever the case is.
Right.
And they're going to
My
take the
s-
house, and they're not going to.
Yeah, they're going to take everything,
They're going to take
essentially.
everything. They're going to punish to
Right.
the full extent.
Exactly. Yeah, and I mean, that's just not
It
a very
happens. It
rare
is.
thing.
No,
I'm
it's
sure
not.
it happens
It's
more
not.
often than not.
And so basically what I do, and I know that all of my colleagues in our firm do, is just because they say they want it doesn't mean we're going to go and try to get it for them.
Right.
So basically what we do, and I think we do it very well, is that we set expectations right from the beginning.
It's a real reality check.
It's
on day one.
yeah, because they'll come in and they'll say so and so had a divorce last year and she got this and she told me this
Right.
and whatever, and what I say is like, okay, well, we've been doing this for X number of years, we've seen this play out so many times. This is the reality of what's going to happen.
Right. But in a lot of cases, the divorce coach is preceded by the friend, the coach,
That's
the
right.
sister-in-law, the old girlfriend from high school, whatever.
Yeah.
And they've been through this,
So
and,
they know.
and oh, they absolutely know.
And they got everything: the house, the car, the
That's right.
dog,
You know,
everything.
And the support, and they never have to go to work ever again.
So if this is the sort of preamble that you've been receiving, clearly when you're in emotional distress, you seek comfort, and you seek comfort from people who are going to give you comfort. And in some cases, some of those people are going to say, you really should just divorce the guy. And I had it happen. A friend of mine, and off you go.
Yeah.
And so you have this series of weird, unrealistic expectations, but you're so angry you don't even know that they're weird or
Yeah.
unrealistic.
Yeah.
So that's where you come in and go, okay, please, off you go. Now, when you take that all-important breath, I have a few things I'd like to say.
Yeah. And honestly, like even after that, sometimes they don't listen. And if that's the case, and Shalina, you can jump in and say what you do, but I don't hire them, or
We won't be retained by them.
Yeah,
Right,
and I
right.
say like, listen, like I don't think this is a right fit for us. I don't think that I'm going to be able to help you get what you want.
Right.
And so then I refer them out
Well,
if
it's
I can,
interesting.
or I just say sorry, we can't help you.
Because both the principals, both Henderson and Heinrich, said exactly the same thing when they were with us last month. Sometimes we aren't going to accept a case or a client because we're not going to be able to help that person. They don't want us to help them, really. They want some kind of
They
hired
want to fight.
gun.
They
A
want
hired
to
gun, and
destroy.
that's
Yeah.
exactly it. Yeah.
They want to destroy. They want to punish. They want to. And
Absolutely.
the
They
thing
want to
about-
drag their name through the mud by
Yeah.
going to court.
Oh,
Like
yes.
it's crazy.
And Rain and Kevin, all of us, we all have families. We all know. We've been doing this for so long that we're not going to take bad instructions. People come to Henderson Heinrichs because we know the law. We know what's likely going to happen.
Right.
We will guide you through the process. We will tell you realistic outcomes.
And we're
But
reasonable.
We're reasonable. We're not going to tell you what you want to hear. If you want, you want somebody that's going to follow instructions blindly,
Right.
then they're going to have to go elsewhere.
Yeah.
It's just
And that's part of it too. Like we all, in our initial consultations, we all explain all the different avenues that they can take to resolve their matter.
Including, by the way, as lawyers, you are required when you're family lawyers. Somebody's sitting across the desk from you, just an emotional basket case, goes into this rant that you were talking about, and after pausing for that all-important breath, you realize that there's a person here who needs to be brought down to reality. There's a gap between what they think is going to happen here and what actually usually does happen, and that's in some cases a huge gap, isn't it?
It is, and it's an education piece as well. We'll often give them some resources. We'll give them some information. We'll show them, the child support guidelines, the spousal support advisory guidelines, just things to give them information, because sometimes they're being so unreasonable
Right.
that you're saying, well, if this was to go to court, this is what would happen. And often, and this is the last place they want to hear it because they're so angry, if you want to suggest counseling, but how do you bring that up when they're yelling and screaming and
Right.
the other person is the person that's 100% wrong? Because 9 times out of 10, it's always somebody else's fault.
Of course.
It's much easier that way.
Right. Quick technical question before but we need to take a break. But I wanted to ask you one little technical question. We've been talking about British Columbia and the new Family Law Act that's just a year old and all the rest of this. But when we talk about the breakup of marriage and divorce, is not the Divorce Act a federal matter? So
Yes.
how do you
Yes.
reconcile those two with new provincial laws, presumably 10 sets of them across the country, and the Federal Divorce Act? How do you square that circle?
Excellent question.
So basically what it is the Divorce Act deals with the divorce. It also has provisions for child support
Okay.
and spousal support. The Family Law Act also applies to common law
Oh, sure.
relationships,
Okay,
right?
sure, right.
Which the
right.
Divorce Act doesn't cover because they're not married, they're not getting
There's no
a
divorce. Exactly.
right?
Okay.
So basically, they work parallel with each other. And if there is ever a discrepancy between the two acts, and both acts do apply,
Right.
then the Divorce Act is paramount
always
because
be
it's
paramount.
a federal legislation.
And so when you get a divorce granted, is it by a federal judge or just a local BC person?
It will be a Supreme Court judge. So the provincial courts cannot grant a divorce.
Interesting.
They can deal with the children, they can deal with the visitations and
Support,
parenting time
yeah.
support, but they cannot deal with property and they cannot deal with the
divorce.
actual divorce itself.
Okay, one other quick question. On the matter of support payments, if there are children, there must always be some arrangement for some kind of support payments, correct?
That's right.
Yes.
If there are no children, is spousal support automatic, or is that negotiable?
It's negotiable.
Negotiable.
Interesting stuff.
Yeah.
We're talking family law. Our guests are from Henderson Heinrichs in Vancouver. Shalina Sayani and Sonia Kainth are associates, family lawyers at Henderson Heinrichs. They are online at hhlaw.ca. We're back with lots more on The Law Show right after this.
There's more of the show still ahead. This is AM 650's The Law Show.